Dear friends, today we are going to see about the section 34 of the Social Security Code. And I am Muralidharan, legal advisor. My contact details are here and there. And also you can visit my Murali HR YouTube channel after this program. Now, what is called the accident? The accident means unexpected and unintentional event that result hurt or loss. That is called the accident. The essential principle to determine the injury means there must be a causal nexus between the accident, that is, work done during the course of employment, and the employee has to prove when the accident was happened inside the employment. And evidence brought on record cannot be subject matter of conjecture or surmise. When we reading from the section 3 of the Employee Compensation Act, it provides compensation to be paid by the employer if personal injury is caused to an employee by accident arising out of and in the course of his employment. And when we are reading the section 2(8) of the ESI Act also, it talks about employment injury to mean personal injury to an employee caused by an accident or the occupational disease arising out of in the course of employment. And section 51(e) of the ESI Act, which states that there has to be nexus between the circumstances, time and the place in which accident occurred. That is very much important to claim the compensation under the ESI as well as from the Employee Compensation Act. When we are reading from the case law that is pronounced by the Andhra Pradesh High Court, Rauri Kotaya versus Dasari Nahavartana Amma. In this case, the personal injury must have occurred at or about the place of employment. That is mandatory. Then, the immediate act resulting in the injury must establish proximity and the nexus with the employment. And these are all the some of the things will be covered under the arising out of the course of employment. One is, if an employee met with an heart attack in the employment itself, that will be covered under the in the course of employment. And going to and coming from the work, that will be treated as a in the course of employment. Dual purpose of doctoring. Employee is asked to drive somewhere to do something of the benefit for the employer. If the employer is asked to do some other job for the sake of his own convenience or for his employment, for the duty for his employment, then that is also treated as a in the course of employment. Premises exception reaches his place of employment, and a special order exception and a special errand exception of duty injuries by third person. These are all the some of the things will be treated as a in the course of out of employment. And when we are coming and reading from the section 34 of the Social Security Code, what is called arising out of and in the course of employment. The accident would have been deemed to have arisen has he been under such obligation. Time of accident being operated by on behalf of his employer or some other person by whom is provided pursuant arrangement by the employer. This is called the arising out of in the course of employment, and is not being operated is in the ordinary course of public resources. Earlier, when we are reading from the ESI, Employee Compensation and other acts, this is not clearly mentioned. But when we are reading from the section 34 of the Social Security Code, it brought everything into the arising out of in the course of employment. And when we are reading from the case laws also, duty is not confined to the period of time of workman commences his work and down his tool. From the case, when we are reading the case of State of Rajasthan versus Ram Prasad. When we are reading the case law, Trustees Court of Bombay versus Yamuna that talks about principles of notional extension. That is also covered under the in the course of employment. When we are reading the Karnataka High Court, United India Insurance Company versus Swida Kadakavalli, in this case also prior permission of his employer leading to his death, that is treated as a in the course of employment. When we are reading the Hathikuli Tea Estate versus Rita Punch, in this case, they covered tidal waves, storms, hurricanes, cyclones, lightning without inclusion of the human intervention. So these are all the things which are covered under the arising in the course of out of employment. When we are reading the case law, even though this is not covered under the Employee Compensation Act as well as in the ESI Act, but now under section 34, all these things are covered under the arising in the course of out of employment. When we are reading the Lakshmi Boy versus Chairman, Port Trust, Bombay, the employee died due to heart disease while on duty. Whether this will covered under the things or not, yes, this will be covered under the act. But employer here, to ensure that if an employee is going outside the premises, now they have to give the outpass or permission approval. Number two, if the employee is traveling outstation or to attend some other work at outside, then on-duty form is prepared. And also infuse the clause in standing order, and if at all any procedure is available, what are all the things will treated as a exclusion, that is important. And ensure the policy satisfy the section 34 of the Social Security Code, and ensure to cover all your role employees under the policy, that is personal accident, either in the personal accident policy or your term policy. That is so much of important, because in section 34 of the Social Security Code, which covers all the employees under the Social Security Code. So if at all anything goes wrong, surely that will comes under the arising in the course of out of employment, and ensure to cover all your whole employees. Cautious about the commutation. See, commutation is so important. Agreement, the renewal of your transporter, that is commuting from from his residence, and also when he is traveling from in his own bike or something like that. Also, wearing PPE avoided by law, employer to detail about the risk signboards, ensure policy renewal, and other matters also important when we are reading the section 34 of the Social Security Code. So I am alerting the employer to cover all your employees, even they are under the NAVs or under the contract or permanent employees or the staff category employees. Surely they should be covered under the personal accident policy or HAM policy. That is important. Thank you. I will meet you once again. Please subscribe to Murli HR YouTube channel.